I'm Busi. In this video, you'll learn about all the court structures, the differences between civil and criminal matters, and all the sources of law. There are many other things you'll learn from this video, so make sure you go through it carefully, or perhaps even several times. This video isn't like a lecture, it's more like a story. I'll be in the video to help you along as best I can. We're going to have fun together, but remember, this is part of your learning program, so you must learn as much as possible. Naturally, it isn't enough just to watch this video. You must also go through all the supplementary material provided. Like the weights on a delicate scale, so too are the laws of our lives.
It's just that I was having a couple of drinks with my friends.
Answer the question, yes or no.
Objection, Your Honor. Badging the witness.
Overruled.
Stop. This is not how it works. You got it all wrong.
Who let her on set? Who are you?
I'm Busi. I was just watching and I couldn't help myself. You're doing this all wrong.
What?
This movie. This isn't how our courts look. This isn't a South African case at all.
It's not supposed to be a South African.
First, in South Africa, we don't have juries. You guys must go.
Where are you going? I'm the director here. Stop now. What are you doing?
Me? It's more your fault. You're the one who wants to show our courts like this.
Well, if you're so good, why don't you direct the movie?
Okay, then.
People, I'm leaving. I said, I'm leaving.
Where's your robe, Mr. Cummins? Costumes. Now, both the attorney and the prosecutor must have robes. There you go. And no wig. This isn't a fancy dress. Thank you. Now, let's see if we've got everything right. There's no jury.
But the judge is still here.
But you're not a judge.
Then what am I? I've got a robe.
Yes, you've got a robe, but you're not a judge. You, my dear, are a magistrate.
What is the difference?
Well, magistrates preside over magistrates' courts, and judges preside over superior courts.
What are these presiding officers and why do they preside over different courts?
Well, presiding officers are the people in charge. They're the ones who preside over the legal proceedings. They consider the law, the facts, and then they must make a decision. About the different courts, though, I'll come back to that a bit later. Right now, let's sort this one out. So, you are the magistrate.
Without the wig, without the hammer?
That's better. You are the prosecutor.
I know that. I work for the state and it is my job to prosecute people who are accused of committing crimes.
That's good. It sounds like you've got it. And you are the attorney. And just some advice. No more jumping up, shouting objection. You must refer to the magistrate as your worship, not judge. This is South Africa, not America. Well, that's it then. We have the magistrate, the prosecutor, and the attorney.
What about us?
Who are you?
I'm the interpreter. I make sure that everyone understands the proceedings in the language of their choice.
And you, who are you?
I am the orderly. I keep order in court and I also call witnesses.
And who are you?
We are the witnesses.
Okay, so that's everyone. The magistrate, the prosecutor, the attorney, the interpreter, the orderly, and the witnesses. That is everyone. All right, let's all take our places then. Someone's missing. Can you tell who it is? The accused.
I was taking a smoke break.
Great, now that must be everyone. I'm not going to tell you who they all are. You must know by now. That's better, much more South African. Now, see if you can tell the difference between this and this. But let's see where this court case began. Imagine you standing at the side of the road. You can see the movement of cars as they rush by to destinations unknown. This is where our story begins, at a busy intersection. Imagine two cars traveling in opposite directions towards the intersection. Can you feel the tension mounting? Suddenly, the two cars collide. Moments later, people stumble from the cars in a daze. And once the shock has worn off, they start blaming each other and a fight ensues. The police and the paramedics arrive. The police take statements and the paramedics take the injured to hospital. Accidents like this are happening all over South Africa as we speak, or rather as I speak and as you listen. Our story today is about one such accident. Let's meet the people involved. We've met this man before in the courtroom. He's the accused, Mr.
Scotch bottle. We met in the court before. I was driving drunk when the accident happened. But I don't care. I didn't cause the accident.
That's not true.
Excuse me, madam. Can you tell us who you are?
I'm Martie van der Merwe, and I was driving the car when the accident happened, and I'm angry. My husband is seriously injured, and I did not cause the accident.
Rubbish!
Hang on. Well, it looks like these introductions have caused quite a commotion here. I believe the police took blood tests from you, Mr. Scotchbottle.
Yeah?
Well, it looks like I'm going to have to leave the introductions there. Well, that's where this whole legal matter began. One car accident caused this whole court case. Now let's follow the events as they unfold. Join me as I speak to one of the police officers involved in the investigation. Can you give us some background about how you fit into the picture?
Well, I am the investigating officer for this matter. It is my job to investigate whether a crime has been committed. I collect all the evidence and submit it to the public prosecutor, who later decides whether we should charge the person.
Can you explain how you collect the evidence?
Sure, I can explain it to you, but I need to collect more evidence and take some statements. Can I show you how I do it?
Great. Inspector Shabalala spent some long days collecting all the information. It was difficult to keep up. He went to the scene of the accident. He spoke to witnesses about what happened in the accident. He also got the blood tests that showed Mr. Scotchbottle was driving over the limit. He then sent all the information to the public prosecutor, who drew up the summons. So what's going to happen next?
Now I am ready to serve the summons on Mr. Scotchbottle.
Can we have a look at it?
Yes. This is the accused person's details. Here are the charges. And this is the place where he should appear.
Are you going to arrest him?
I don't think that will be necessary. I could have if I wanted to. There are basically 3 ways of securing the attendance of the accused in the magistrate court. Arrest is one way. Another is by notice issued by a peace officer, but I'm going to use the summons, which is issued by the clerk of the court and is served by me on the accused. In the High Court, the process is different. There, the accused is sent a summons and an indictment. It looks like this. In the matters that come before the court, I work with the state advocate, but in this case, because it is in the magistrate's court, I work with the state prosecutors. I am on my way to drop off the summons now.
So your car, whereabout is your car now?
No, I've got a buddy, he's going to fix it up there by his house.
Oh, that's cheaper for you then.
Yeah, it's much better. I don't have to worry about it because those cops are never going to catch me. There is no way.
And sure, what about the blood test? Didn't they take a blood test?
Yeah, they took a blood test and that stupid policeman took a statement from me.
Yes.
But you know what the cops are like? They'll never do the paperwork.
Yeah, they're too lazy.
Yeah, they're much too lazy. And that, besides, that woman, she just jumped right through the stop street.
Yeah, no, women's rights.
Terrible.
Terrible.
Terrible. Who can that be? Yeah. Yes.
Good morning.
Hi.
Are you Mr. Scott Bottle?
Yes.
Yes, summons for you.
Summons?
And the charges are here, as well as the dates when you will appear in court.
What is this?
What?
Failure to comply with the regulations, you will be jailed. Please sign here for me.
Jail? Where, Mr. Sign?
Yeah.
I hope you've got a lawyer.
Yes, I'm going to have to get one.
Are you sure you must
And
sign
your full
that?
name's there? Yes, yeah.
And the investigating officer gave me this piece of paper.
I see. Tell me what happened.
When I came to the intersection, I swear I wasn't even driving fast. And then the woman just jumped right through the stop street. And you know what these women drivers are like? They don't watch the road. And then when the cops came, you should have seen how they treated me. Yes, they said I was bad. They said I'd been doing things and giving them trouble, and I hadn't done any of that stuff. It was that other woman who had just driven like that, crashed right into me like that, hell. And then this cop comes and gives me trouble. He takes my statement. He treats me like I'm some sort of scum or something, man.
This piece of paper is a summons. Let me show you. These are the court details. That's your details. And this is the charger. Driving under the influence of an intoxicating substance, alternatively driving while blood alcohol is more than 0.05, reckless and negligent driving, and failing to stop at a stop sign.
But why is the state involved? It's got nothing to do with them. It's between me and the woman who was in the car.
That may be true, but the state always has an interest when there's a possibility that crime might be committed. The state has to prove that you have committed these crimes. The public prosecutor has to prove beyond a reasonable doubt that you did in fact commit these acts.
What?
It means that the public prosecutor will have to prove beyond a reasonable doubt. In other words, that there's no doubt that you have committed these crimes. Don't worry, it's much harder than the onus of proof in a civil matter, where the plaintiff, the person bringing the action, has to prove his case on a balance of probabilities.
You mean if I go to jail, those other people can still sue me? Is that why she's at that lawyer next door?
Oh, is she?
Yes. As I was coming to your office, I bumped into her again, just outside. She's going to the lawyers next door.
That means that they might be considering bringing a civil case against you.
Oh, no.
Don't worry about that now. First, we must prepare for your criminal case. Your full names?
Scott Scotch Bottle.
Your address?
21 Roots Road, Berea, Durban.
Please come in. Hi, good morning, Marty.
Good morning, Jane.
Please sit down.
Thank you.
Yes, what can I do for you this morning?
Thanks for offering your help. We didn't know who else to turn to.
It's always a pleasure to help my neighbors. Is it about that motor vehicle accident you had recently? How's your husband? I hope he's out of hospital.
Carl is getting better. He's at home now, but naturally he's very upset about the whole incident.
Well, I'll see what I can do to help.
I'm very worried because I saw the man who crashed into us going to his lawyers next door. I hope he's not going to sue us.
Tell me exactly what happened. I want you to tell me the whole story from the beginning.
Carl and I were going to the shops, and as we neared the four-way stop, you know the one just in front of Checkers? This guy just drove through the stop street, and he was drunk. And so I came to see you. Carl wants to know if he can sue this man and send him to jail.
I'm not quite sure what Carol means, but let me explain to you a little bit about the types of cases that can follow from this motor vehicle accident that you guys had. You see, there are criminal cases and civil cases. It is usually the criminal cases that result in people ending up in jail. There are three things that the state does in criminal cases. It investigates the cases, it charges people, and then prosecutes them in court. So there's no way Carol can sue and send anyone to jail. That is the function of the state.
You mean like the policeman who came and took my statement?
Yes. The police investigates the crime. The public prosecutor decides on the charges he wants to bring and then prosecutes the person in court. In criminal cases, the police and the prosecutor represent the state. That is why in criminal cases, the contesting parties are called the state and the accused.
But then what can we do? The man was driving while drunk. He's ruined my car. And Karel has huge medical expenses. He hasn't been to work, and he hasn't been paid. And what about all the pain and suffering?
I'll help you to bring a civil claim against this man, Mr.
Scotch Bottle.
Yes, Mr. Scotch Bottle, for the damages he has caused you.
So we can sue him?
Yes, from what you have told me, I think you do have a good case. I'll get onto the case right away, and I'll call you to arrange for our next meeting.
Thanks, Jane.
It was my pleasure.
Goodbye.
Bye-bye.
Now, I don't know about you, but I found all of that quite confusing. Why don't we go back to the courtroom to see if we can sort all of this new information out there? That's better. I thought that I'd meet you back here at the Magistrates' Court because you've met everyone here before. This is the criminal case that the lawyers were talking about earlier. You'll remember that the parties involved in criminal cases are the state, represented by the public prosecutor, and the accused, Mr. Scotch Bottle, represented by his attorney, Mr. Cummins, and the presiding officer in the Magistrates' Court, the magistrate. Perhaps you can tell us, Your Worship, who has the onus of proof in criminal matters?
The onus of proof rests with the state.
Yes, as a representative of the state, I must prove the case beyond reasonable doubt.
Okay, so that's what happens in criminal matters.
But what about my civil matter and the money I've lost?
Well, good question. Well, let's stay in the Magistrates' Court for now, but let's change the scene from one of a criminal case to one of a civil case.
Yes, let's say that I'm suing Mr. Scotch Bottle for the damage he did to my car.
Good idea.
I don't think so.
First, in a civil matter, the parties are not the state and the accused. They are the plaintiff and the defendant. You will have to go. There are no prosecutors in civil matters.
But what about my lawyer?
Good point. The plaintiff is represented by an attorney. Where is the plaintiff's attorney? Oh, there you are. And of course, we have the defense attorney. I said defense attorney. Come on, guys, get it right.
So I've changed from being the accused to being the defendant. That makes me feel a lot better.
I wouldn't be so sure.
Why? What do you mean?
Well, you may not be facing criminal charges in this civil matter, but for us, in civil cases, the onus of proof is always a lot easier.
It is true that in a criminal case, the state has to prove your guilt beyond a reasonable doubt. In a civil case, the plaintiff has to prove her case on a balance of probabilities. It's easier, but they still have to prove their case, and they don't have a chance.
We'll see about that.
Okay, that's enough of that. So, this is everyone involved in the scene, and these are the characters involved in a civil case in the Magistrates' Court.
What about me?
What about you?
Am I changing to anyone else?
No, the magistrate remains the magistrate in the Magistrates' Court.
Can I wear this wig?
No, you can't wear this wig. Right, titles. This, ladies and gentlemen, is a typical South African courtroom scene.
Tell them it's a civil matter.
Okay.
In the Magistrates' Court?
Okay, keep still, everyone. This is a typical scene of a civil case in a magistrate's court in South Africa. So, let's recap. See if you can spot the difference between these two pictures. So, how did it go? Can you spot the difference? I can spot the difference. Can you? Now I'm going to take you to the High Court.
Why has Busie brought us here?
Well, this is the High Court. I think Busi just wants to make the viewers aware of the difference between the High Court and the Magistrates' Court.
Is there a big difference between the two?
Yes, there is a difference, especially in the types of cases heard.
You mean like criminal cases and civil cases?
Not exactly. Both the Magistrates' Court and the High Courts can hear criminal and civil cases. What I actually mean by types of case is, in fact, the type of criminal case and the type of civil case. Let me give you an example. The criminal offense of high treason may not be heard by a magistrate's court. Moreover, the sentence passed by a magistrate's court is usually limited. The same applies to civil matters. If the amount of money claimed is high, then such a case may not be heard in the magistrate's court. That is why we will probably sue Mr. Scotchbottle here in the High Court, because from what I have worked out, the amount of money we are going to claim from him is large.
Did you hear that?
Yes, don't worry. Remember what I said before. They still have to prove their case on a balance of probabilities. They will never be able to do that.
But why do we have to come to the High Court? I mean, what's wrong with the Magistrates' Court?
Nothing, I suppose. It's just that the amount they claimed is too high for the jurisdiction of the Magistrates' Court.
The what of the Magistrates' Court?
Jurisdiction, the competence of the court to hear the matter. In every court, be it the High Court or the Magistrates' Court, there must be some factor connecting the persons before the court to the geographical area which the court covers. In your case, the accident happened in the geographical area of this High Court and of the Magistrates' Court we were in.
I see, but she wasn't talking about jurisdiction in terms of geographical area. She was talking about an amount of money.
Yes, there are a lot of factors that determine which court has jurisdiction. In a criminal matter, it's the type of offense or the possible punishment that determines which court can hear the matter. In a civil case, it's the type of claim or the amount claimed that determines which court has jurisdiction. The Magistrates' Court does not have jurisdiction if the amount claimed is too high.
But how much is too high?
That changes from time to time. Listen, it's not so much that you need to worry about that now. We'll worry about that when we get to it.
But what if we do not win our case?
Then we will appeal.
You mean there's a higher court than the High Court?
Yes, of course. Look, at the bottom are the magistrates' courts. They are divided into the regional and the district courts. We call those the lower courts. Above them are the higher courts, which constitute of high courts. And above the high courts is the Supreme Court of Appeal. And right at the top is the Constitutional Court.
What?
Let me draw it for you. First, there is the Constitutional Court, which only hears constitution matters. Then below that is the Supreme Court of Appeal, which only hears appeals. Below the Supreme Court of Appeal are the high courts, which have different divisions all over the country. They hear criminal and civil matters and constitutional matters. Those are the higher courts. The lower courts are the magistrates' courts, and they are divided into regional and district courts. Magistrates' courts also hear criminal, civil, and constitutional matters.
Okay, so if we lose in the High Court, we can appeal to the Supreme Court of Appeal.
That's correct, but we will not need to appeal because we are going to win this one.
Why didn't you guys wait for me? Oh, Mrs. Van der Merwe, can you remind us, what are you doing here?
Yes, this is the High Court, and I'm going to sue the pants off that monster.
That's right. Now we get to see what the High Court looks like. Well, this is a civil case in the High Court. You have the plaintiff and the defendant and their legal representatives, and you have the... What are you doing?
Nothing. Nothing. Why can't a magistrate in the High Court wear a wig? I've seen it on TV.
Well, first, presiding officers in the High Court don't wear a wig. No presiding officers in South Africa wear a wig. Secondly, presiding officers don't have little gavels. But all of that pales into insignificance when you consider the fact that there are no magistrates in the High Court. The High Court only has judges, so you have to go.
You heard her. Just leave. Leave now.
So this is a civil case in the High Court. You have the plaintiff and attorney, but you, Mr. Scotchbottle, you can stay, but you're no longer the defendant. You are now the accused again. And you will have to go. Where's the state advocate?
I don't just want an attorney. I want an advocate. Why can't I have an advocate? Where's my advocate?
You can have an advocate, Mr. Scotchbottle, if you want to. But an attorney can also appear in the High Court now.
Well, I want an advocate.
Okay, I'll work out the extra costs of an advocate.
The what? No, you'll be fine. You'll be fine.
All right, everybody, your attention, please. This is the judge, the accused, and his attorney.
Or advocate.
Or advocate, and the state advocate. The judge's clerk, interpreter, and court orderly. Let us compare that with the civil case in the High Court. In our story, the criminal matter will be heard in the magistrate's court and the civil matter will be heard in the High Court. But we want you to know the difference between the criminal cases in the magistrate's court and the High Court. See if you can compare the two criminal cases, one in the magistrate's court and the other in the High Court. And the two civil cases, one in the magistrate's court and one in the High Court. Well, that was fascinating, and I'm sure that you're all well informed about our courts. But let's go back to the story. Will Mr. Scotchbottle be convicted? Will Mrs. van der Merwe succeed in her civil claim? Remember, in our story, the criminal matter will be heard in the magistrate's court and the civil matter will be heard in the High Court, even though we've shown you the parties in the magistrate's court and in the High Court for both the civil and criminal matters. To find out what happened, we join Mr. Scotchbottle in the magistrate's court.
After weighing up all the evidence presented by the state, I found the accused not guilty on the charges of reckless and negligent driving and failing to stop at a stop street, but guilty on the charge of driving with a blood alcohol level of more than 0.05%.
This was the scene at the magistrate's court 2 weeks ago. A distraught Mr. Scotchbottle left the courtroom before I could ask him for his reaction. But a visibly pleased prosecutor made her way back to her office to begin work, no doubt, on her next case. So, there you have it. The public prosecutor discharged the onus of proof, which you know in criminal cases is beyond a reasonable doubt, but was not so successful in discharging the reckless and negligent driving charge. Let's go live now to the civil claim in the High Court to see whether Mrs. Mothibe has been more successful. The question on everyone's lips is whether she'll be successful in discharging the less burdensome onus in civil cases, that of proving your case on a balance of probabilities.
In this case, I find for the plaintiff.
Well, in a remarkable turn of events, Mr. Scotchbottle got off on the reckless and negligent driving charge, but lost his case in the civil trial. Well, sorely disappointed and visibly angry, he made a dash for the courtroom doors with his attorney in tow.
I'm going to appeal this matter. I'm going to take it right to the Constitutional Court.
Well, yet another rude outburst from Mr. Scotchbottle, typical, though, of his behavior throughout the whole trial. Well, as you probably know, he cannot take his case to the Constitutional Court because the Constitutional Court only has jurisdiction over constitutional matters. But he can take his appeal to the Supreme Court of Appeal. But word on the ground has it that he won't have much success there either. Well, Mr. Scotchbottle and his attorney are probably quite relieved to be out of the High Court after the relentless vigour of the plaintiff and her attorney, Mrs. Mothibe. Mrs. Mothibe, a victory for you. How does it feel?
It is very good to succeed, but we must always remember that the aim of this case was not about personal victory. Neither was it an attempt to punish Mr. Scotchbottle. The aim here as in other civil matters, was to compensate the person making the claim. I am obviously very pleased that the Van der Merwes will be able to get all the money that they spent as a result of Mr. Scotch Bottle's actions.
What about you, Mrs. Van der Merwe? How does it feel?
I just want to say to all those driving drunk on the road, watch out. If the criminal case doesn't get you, the civil one will.
Well, that was Mrs. Van der Merwe having the last word. Now let's join the winning team back at Mrs. Mothibe's office to find out how they made all of this happen. Well, we've almost come to the end of this program, and all that's left to do is to join Mrs. Mothibe, the attorney for Mrs. Van der Merwe, in her office to find out exactly how she managed to discharge her onus of proof in the High Court. Mrs. Mothibe, what's your secret?
Ironically, Busi, the secret is no secret at all, besides hard work, which I believe is the key to every success. In law, you have to make a strong legal argument.
How do you do that?
You must find the law to support your case.
Where do you find this law? In the library?
You might find it in the library, but it is usually specialist law libraries that keep legal information. Most lawyers, like myself, usually keep such legal information in their offices, either in the form of books or on their computers.
So when people ask where they can find the law, they're not just talking about the physical place, like the library, but they're also talking about where the law comes from.
That's right. We call it the sources of the law.
In other words, where the law comes from.
That's right. In South Africa, we have many sources of law. The basis for any good legal argument is sources of law, especially authoritative sources of law. The first place in which I look for authoritative sources of law is legislation. This is the law that the state makes. One important organ of state that makes legislation is Parliament. Parliament passes legislation. Let me show you.
But I thought Parliament passed acts. I mean, I've heard people say today an act of Parliament was passed.
Yes, that's correct. Legislation is known as acts, sometimes also as statutes. These are basically different terms to refer to the same concept. Unfortunately, I could not find a piece of statute that refers directly to the case that we are dealing with. But I do have an example of a statute.
But what about the case that you won? Why must we look at this act first?
We'll look at that case later. But for now, let me show you how I go about looking for law. I start with legislation because it is an important authoritative source of law. So let us try to find that act. Every year, Parliament passes hundreds of acts. Each act has a short name as indicated here in bold, Choice on Termination of Pregnancy Act. They all have a number. This is the chronological number 92. And this is the year in which the act was passed, 1996. In other words, this was the 92nd Act of 1996. These acts are made known to the public through a publication called the Government Gazette. Commercial publishers, however, collect all the statutes and publish them in a form like this so that we can have them all together.
And this is obviously when the president signed the act, and this is when it came into force. So this act was passed in 1996, but only came into effect in February 1997.
Yes.
What is this in bold under the word act?
That is called the long title of the act. It states what the purpose of the act is. So in this case, the purpose of the act is to determine the circumstances in which and conditions under which the pregnancy of a woman may be terminated and to provide for matters connected therewith.
What is the preamble for?
The preamble sets out the underlying philosophy of the act.
And all these numbers?
Those are the numbers of the sections of the Act. Every Act is divided up so that it can be referred to easily. This whole part here is Section 2. The part that follows this one, which is in brackets, is subsection 1. This part that follows A, in brackets, is called a paragraph. And these Roman numerals indicate subparagraphs.
I see. So if I wanted this part of the Act, I'd say I'm looking for Section 2, subsection 1, paragraph B, subparagraph 3 of Act 92 of 1996.
That's right.
What is this section with all the words about?
Good question. That is called the definition section. It is usually the first section of the Act. The purpose of this section is to define some of the words as they are used in the Act. And this last section gives the short title of the Act and the day of commencement.
So why did you say that you always start by looking for legislation?
Legislation is a powerful source of law. Some even say it's the most powerful source of law.
But I thought the Constitution was.
The Constitution is a special type of legislation. Let me see if I can show you that. It was passed by Parliament. Its short title is the Constitution of the Republic of South Africa, Act number 108 of 1996. But you are right. The Constitution is the highest source of law, even above other legislation, because all legislation must be consistent with the Constitution.
Okay, I see. So if legislation is a powerful source of law, what are the other sources?
The next source of law is one that you should be familiar with.
Me? How would I know?
Because you have already experienced it. Court decisions.
Oh, of course.
I hope the decision of the case we're involved in has been reported, because it's been some time now since the case occurred. Ah, yes, it has been reported. And you know, it's not every case that gets reported.
I believe so. Only important cases in the High Court. No Magistrates' Court decisions are reported.
Here, this is the civil case. Since 1947, cases have been reported in South Africa by commercial publishers. To find the case law, you need to buy the publications where the cases are regularly reported.
This is the name of the case. I recognize the parties involved, Mrs. van der Merwe and Mr. Scotchbottle.
That's right. The plaintiff and defendant. This is the court where the matter was heard, Natal Provincial Division. And this is the name of the judge who heard the matter, Makhabu J.
What's her first name? Joan?
No. The J does not stand for her name. It stands for judge. In other cases, judges have AJ for acting judge or JP for judge president behind their names. There are a lot of other letters that indicate the judicial status of the judge. Now, where were we? Oh yes, this is the date when the case was heard, 21st May 2000. This section here contains the main points or catchphrases of the judgment. The publishers put it in to help us quickly see what happened in the case. You can see it has all these dashes because it is in telegraphic style.
What is this then? It doesn't look like it's telegraphic, but it still looks like a summary.
Yes, it is a summary. It's called the head note. The publishers also write this for our convenience, so you cannot always rely on it. You should read the judgment itself, which is over here. After these two Latin phrases, cur ad vult and postea.
What?
Cur ad vult, which is short for curia adversari vult, which means the court wishes to consider its verdict, and postea, which means afterwards.
What's that all about?
Well, the court heard the matter. Then it needed time to think about what its decision was going to be. Then, after it had considered, it gave its verdict.
Does a criminal case look the same?
Almost. The only difference is in the name of the case. In the civil case, the parties were Mrs. van der Merwe and Mr. Scotchbottle, the plaintiff and the defendant. Here, they are the state as indicated by the S and the accused Chetty.
Oh, I get it. That seems like a lot of law for such a small case.
Well, that is not all. There are other sources of law. There is common law, there's customs, and there's indigenous law. These are all the sources of law that you need to support your legal argument.
Wait, say that again.
We have indigenous law, customs, common law, case law, and legislation.
But is all indigenous law written down?
No, indigenous African law is not all written down. It lives in the hearts of the people and is essentially oral. Custom is also not all written down. After all, it is certain actions and behaviors of people.
So, not all law is written down?
Exactly. Even the law that is written down still has to be applied. As we all know, the law in the books and the law as it is actually applied are two different things.
Yes, I suppose that must be true. But does the law that's written in these books have an order of authority? Are they stacked in order with the most powerful on the top and the least powerful at the bottom?
Not really. It's not that simple. The sources of law interact in different ways. Indigenous African law and common law should be on the same level. At least that is what the Constitution says.
That sounds interesting and complicated.
Yes, it is. But we don't have time to go into it right now. I have another case to prepare for.
Thank you for all your help, Mrs. Muthive. We've certainly learned a lot from you.
It's a pleasure.
Well, wasn't that an exciting journey? We met some wonderful people along the way, but as is the case with any journey, we also met some not so wonderful people. It was hard work at times, but it was worth it. Now that you know more about the South African legal system, you can explore it further. You can start by watching this program again if you didn't catch it the first time. Well, it's been fun for me. I hope that you enjoyed it. From me, Busi, until next time.